Good morning. Every now and then, we read reports of the Supreme Court acquitting those wrongly convicted of serious offenses and handed down the death sentence. In most cases, these individuals have been on death row for years. But I cannot remember the last time there was public outrage or really any meaningful dialogue or debate in mainstream media. People losing 10, 12, 15 years of their lives on death row for crimes they did not commit just does not rile us up. Not enough. Very likely because, as empirical evidence tells us, the marginalized and the vulnerable make up the overwhelming number of people sentenced to death in India. You would perhaps ask, surely there are safeguards, procedural and otherwise, baked into the criminal justice system. You would reflexively say, isn't the death sentence given in the rarest of rare cases? In any case, shouldn't the prosecution have to prove the guilt of the accused beyond reasonable doubt? And even if the trial court were to erroneously sentence an accused to death, wouldn't that sentence become operational only subject to High Court confirmation? Well, over the next 20 odd minutes, Professor Anup Surendranath, Executive Director of Project 39A, a criminal justice program at the National Law University, Delhi, will answer those questions. Professor Surendranath is the lead author of the Death Penalty in India report published in 2016, the only report of its kind. It is a comprehensive and in-depth look at the manner in which the death penalty is administered in India. This is your weekly fix. I'm Smita Nair. Why are we discussing the subject today? The criminal reforms advocacy group that Professor Surendranath leads, in its latest report, tells us that trial courts across India passed 165 death sentences in 2022, the highest in a single year. At the end of 2022, 539 individuals were on death row, the highest since 2004. The other reason is that the Supreme Court in 2022 asked a 5-judge constitutional bench to decide on its concerns on death penalty sentencing, chiefly the arbitrary manner in which it has been administered in violation of an existing framework. Before we get to the questions, I also want to clarify that these concerns are not limited to death sentences given to those wrongfully convicted. Even in cases where the prosecution has been able to meet the standards set for conviction in a criminal trial, the sentencing framework laid down by the Supreme Court in weighing mitigating circumstances has not always been observed while trial courts handed down capital punishment. So to begin with, Professor Surendranath, for the benefit of many of our viewers who perhaps won't be entirely conversant with how the criminal justice system works, could you give us clarity on what happens procedurally in the trial court and subsequently in appellate courts in cases where a death sentence is handed down? At every stage, is evidence that led to the conviction re-evaluated, or does the High Court and Supreme Court only scrutinize fairness in sentencing? This is a question we often are asked.
Yeah, thank you, Smita, for having me today. And in response to your question, initially, it is the trial court that has to give the death sentence. And once a trial court gives the death sentence, and even while giving the death sentence, it has to decide between life imprisonment and the death sentence. And there's been a lot of controversy about how judges go about deciding whether to give you life or death. And this concerns have been of arbitrariness and lack of any sort of consistency and a whole lot of subjectivity coming in. Factors like public conscience coming in, collective conscience coming in judges' decisions to give the death sentence. But anyway, even if the trial court gives the death sentence, it can't be carried out until the High Court also confirms the death sentence. So it goes in a confirmation proceeding to the High Court, where the accused person or the person sentenced to death also files his or her appeal. And the High Court, it's meant to hear the evidence and the sentence all over again because it is a confirmation proceeding. And if the High Court gives the death sentence, the death row prisoner can file an appeal in the Supreme Court. And the Supreme Court can decide to hear the appeal either on evidence or just restrict it to the issue of punishment of whether the death sentence is called for. But that is on a case-to-case basis. And the court sometimes, most of the time, hears the case in its entirety, but there have been a fair number of instances where they say, okay, we just want to hear arguments on sentence. We're not interested in hearing arguments on evidence. But in all of this, to remember that we're talking of a section of our prison population where death row prisoners belong to the poorest and the most marginalized sections, documented very well by our work and many others all across the world. It's true that death row prisoners perhaps receive the worst of legal representation coming up through the system by virtue of their poverty. So, this kind of evidence really hasn't received the kind of close attention and scrutiny and hasn't been presented before courts with the kind of necessary rigor and scrutiny that it should be, especially given the fact that we're talking of the death penalty. And, and that really plays out in so many of our cases.
Just to take that point forward, Professor Surendranath, based on your research and the Supreme Court's observations in cases where it has, looked at evidence again and acquitted death row convicts, is it fair to say that wrongful convictions for very serious offences are not as rare as is widely believed to be? That the police don't always meet due process requirements. Sometimes there's even manipulation of evidence. That the prosecution knowingly pursues conviction, even goes ahead and seeks capital punishment in such cases, and that trial courts sometimes casually hand down death sentences in violation of what is at least understood to be a laid down framework. If this is happening, why is it happening? You answered a bit of that, of course, in the previous, in answer to the previous question, but
no, absolutely. And I think I think everyone knows there is a massive crisis in our criminal justice system in terms of wrongful convictions and wrongful prosecutions. But it is an issue that just hasn't received the kind of attention it needs. And it is not looked at with the kind of urgency that it must be. And look, we are not unique in that wrongful convictions and prosecutions are not some reality that is true of the Indian criminal justice system alone. It's true across the world. But the point is, we pretend as though that is not a reality in our criminal justice system. And we really haven't addressed it. We don't know the extent of it. We know it is rampant. Given the structural realities of the manner in which the police carries out investigations, be it in terms of use of torture, the manipulation of evidence, the manner in which prosecutions are carried out, how it is the poor that are trapped within our criminal justice system and cannot afford the kind of high quality legal representation that is required to expose these vulnerabilities and these manipulations in the criminal justice system. It is, we've barely scratched the surface of wrongful prosecutions and wrongful convictions in this country, right? And even in the US, you have seen how the Innocence Project has contributed so much to changing the public perception around how vulnerable the criminal justice system is. And, it is only that is true here only multiple times. But, we really haven't generated that momentum or document. And it's difficult to do in our system, right? We need to do it case after case after case, and to expose the extent of wrongful convictions is an urgent need of the system, especially given what investigation and prosecution agencies get up to in this country. Yeah.
Right. For the benefit of our viewers, we'll also be linking to the reports we referenced earlier in the introduction to this show, so you can sort of perhaps read it yourself to get a better sense of what Professor Surendranath is referring to here. That the death penalty can only be imposed in the rarest of rare cases, Professor, was established in the Bachchan case of 1980. Can you expand on what this principle is insofar as it being a procedural bar?
Yeah. Just before I get to that, I just want to make one point on an indication on the wrongful prosecutions. In the last 14 months, the Supreme Court has acquitted 8 death row prisoners, right? This is after the trial court and the high court had not only convicted them, had given them the death sentence. The Supreme Court then reassessed the evidence and acquitted 8 of them. And this is not some unique year. Even our own work over the assessment of 15 years of statistics show that for every 100 death sentences that are handed out by the trial courts in this country, about 30 to 35% ultimately result in acquittals, right? Over the course of their judicial life or that legal life of that case. It's a shocking number, right? It's a shocking number that out of 100, 30 to 35 ultimately are acquitted. And these things, I guess, these things are so normalized, and these things just don't shock us anymore, right? And then it exposes the vulnerabilities of the criminal justice system. Now, coming to your question of the rarest of the rare, When the Supreme Court was asked to decide whether the death penalty is constitutional in 1980 in Bachchan Singh, it said, okay, it is constitutional, provided you decide to give the death sentence according to this framework that we are laying down, right? And it said, okay, you have to identify aggravating factors, you have to identify mitigating factors. Once the person is found guilty, you move to the sentence and you identify these aggravating factors and these mitigating factors. Judges have to assign weight to them, and then come to a conclusion as to whether the death sentence is called for. And one of the determinations they have to make is whether the alternate option of life imprisonment is unquestionably foreclosed, right? And you have to remember that under our criminal procedure code, when there is the option of life or death, judges are expected to use the life imprisonment as the default option. And if they want to give the death sentence, the criminal procedure code requires them to give what known as special reasons. And the court in Bachchan Singh was saying, these are the special reasons. This is how you go about giving special reasons. You have to identify aggravating factors and you have to identify mitigating factors. And, it sounds logically like a good framework. But over 40 years of working the rarest of rare doctrine, as everybody knows it, the Supreme Court itself has acknowledged the complete breakdown of that doctrine. The Law Commission of India has acknowledged it, right? We did a study with 65 former judges of the Supreme Court. They also acknowledged it. It means nothing now. It means whatever you want it to mean. It is an empty vessel as to what rarest of rare is, right? Judges have adopted all sorts of methods and meanings to this idea. And this is not me just saying it. The Supreme Court itself has said it, right? That, okay, what does this mean now? It seems to mean one thing for one judge and, another for other. And there is a complete breakdown of the rarest of rare doctrine. And now you see, 42 years later, the Supreme Court formally, for the first time, sending it to 5 judges last year, saying, okay, now we need to resolve some very crucial, important elements. And the very foundational issue of who is going to collect these mitigating factors of all these poor people, who is going to go and investigate their lives and say, yes, these are the mitigating factors in their cases and from their lives that need to be presented to court. It's very well for the law to prescribe a framework, but what it did not do was to say who is going to do this for all these poor people, right? And so for 42 years, we've gone about death penalty sentencing without anyone really bothering about, are we giving them a fair chance during sentencing, right? Is there a fundamental ounce of fairness in our sentencing procedure? And I'm so glad that the Supreme Court, at least now, has acknowledged that this is something that we need to fix, right? It has taken 42 years, but I guess better late than never. And for the first time, 5 judges after 42 years will consider some fundamental elements of death penalty sentencing in this country.
Right. Just for a bit more clarity from a layperson's point of view on understanding, how this decision is arrived at, what should be germane as per existing law and procedure and guidelines to deciding the death penalty? Should it be the nature and severity of the crime? And this is the more sort of widely understood idea of what constitutes a rarest of rare case, the severity of the crime, or should it be the consideration of, as you said, mitigating circumstances? If you could sort of tell us what these mitigating circumstances could be, and if I could also request you, Professor Surendranath, because this is a case that is often cited, it's a recent one, the last execution was carried out in this case in the context of Nirbhaya. If you've studied the sentencing in that matter, was it the severity of the crime? Were the existence of mitigation factors, if at all, looked at?
Yeah. Thanks, Smita, for asking that. That's really the crux of the matter, right? I mean, that's the crucial question. The law is very clear, right? It is that, and we may not like what the law is, but that is what the law is, that you have to consider both the nature of the offense and also circumstances as related to the accused person's life and conduct, right? Both in the lead up to the offense, the manner in which the offense was committed, and also post-offense conduct in prison, right? So judges have to elicit and look at the nature of the offense, that is the manner in which the offense was carried out, what the offense was. So those tend to be the aggravating factors, right? That is what is naturally on record, because the state is prosecuting you. The brutality of the offense, and that tends to be the predominant framework within which judges decide. And that precisely has been the problem, because that is not the only thing that the law requires you to do. The law requires judges to pay equal attention to the circumstances of the accused. You can't decide to give the death sentence purely on the brutality of the offense, right? As I said, we may not like that as lay people, as in generally in society, we may not like that. We say, why should we care about the circumstances of the accused? And there are very good philosophical and criminological reasons for the law saying that. We may or may not agree with it, but that's the law. That's what the law requires for it to be constitutional and to have the death penalty. Unfortunately, what has happened over 42 years is death sentences are given by looking only at the brutality of the offense, right? And that is precisely what has also happened in the Delhi gang rape case, right? In terms of, if you look at the sentencing that has happened in the trial court and the high court and the Supreme Court. Look, and I think very often these high-profile cases tend to skew and polarize discussions, because we're like, if we don't give the death sentence in this case, in which case will we give it, right? I'm sorry, that is just misunderstands the legal process and the legal requirements. Irrespective of the brutality of the offense, the law requires a very serious, in-depth effort to understand the circumstances of the accused, give it appropriate weight, and then come to a decision. And I'm sorry to say that in the Delhi gang rape case, that process was not followed sufficiently at all. It might still have resulted in the death sentence. I mean, that's not for us to decide. That's a judicial determination to make, right? But the point we need to ask is, to what extent did we actually follow this process required by the law in understanding the circumstances of the accused? And I think it's quite plainly obvious that we really didn't care about that, because everybody was just so taken aback and shocked by the nature of the offense. It was almost like a foregone conclusion, right, that the death sentence had to be given.
Right. Again, if we were to, does there exist, let me put it like this, does there exist the option of somebody who is convicted of beyond reasonable doubt of a crime such as the Nirbhaya case or the Bilkis Bano case, again, the brutality of which is well documented, I don't want to repeat it, we know what happened, to allow for life in prison till death, without remission, without probation? Is that there in our does that provision exist? I ask why, because I remember the conversation when the convicts of Bilkis Bano were released on remission as well, and the fact the details came out about how they were out for so many days on probation multiple times, despite how heinous the crime was. So the counter to what you said about the Nirbhaya case and shouldn't this be fit for death penalty is there a provision that exists that allows at least for them to be behind bars?
Yes, absolutely. It has been developed judicially also that if judges want to commute, especially, and this is applicable only to High Court and Supreme Court judges. There is the decision of the Supreme Court in Union of India versus Sriharan. It says that when you're commuting a death sentence, you have the option of saying that I will require this prisoner to live the rest of her or his natural life in prison, and the state cannot invoke its remission powers, right? The court can say that, right? It can say that, oh, you will not invoke your remission powers for 20 years, 30 years, 40 years, or rest of natural life, right? The court has the power to say that in when it's commuting the death sentence. That is, the High Court and Supreme Court judges can say it. The trial court judges cannot do it. So that is on the judicial side. Even for even if it is a murder case, right? But the newer legislative provisions, right? When I say newer legislative provisions, I mean the amendments that were brought to our criminal law after the Delhi gang rape case and thereafter now the legislations also provide that in certain kinds of offenses, you can sentence people to the rest of their natural life, right? Yes, so even when you're commuting the death penalty, the judiciary itself can do it if you're in the High Court and the Supreme Court. But Smita, I think there's a larger issue to us. While use and I think you will see there's an increasing use of these non-remission based long life imprisonment sentences while the Supreme Court and the High Court are commuting death sentences. But there's a larger question there on punishment itself, whether that is the right direction to go. So as much as somebody who works on the death penalty and against the death penalty, I'm glad that the death sentences are removed and they're given life imprisonment. But it almost seems I don't know. I don't. It doesn't seem like a victory when people are asked to spend these long sentences without remission in prison, and that is a broader conversation we need to have as a society on how much we want to punish and how harshly we want to punish. All those are deep socio-political conversations, and I think we're all aware where we are headed in that direction. And unfortunately, we want to criminalize more. We want to punish more. And that seems to be our approach to social problems, right? Criminalization seems to be our answer to everything. And I think history has shown that it's a rather poor tool for solving social problems.
Right. I can't remember the last time a politician even sort of in the public domain discussed reformation, as a principle. It is this. The next question is a corollary to really what you've been discussing. The 2020 project that you did, the study that you did, showed that 72% of all cases in which the Delhi trial courts awarded the death penalty from the years 2000 to 2015, the decision cited collective conscience of society as an influencing factor. Is this the same as public opinion, as you said? And how much of this sort of weighs on the trial court judges and even the high court judges perhaps while deciding?
It's a very dominant consideration, and quite honestly, there's no other way to say it. It is an illegal consideration. The judgment in Bachchan Singh is quite clear that public opinion or collective conscience is not a consideration while deciding whether a specific individual deserves a death sentence or not, right? You have to, as I said earlier, you have to take in the aggravating factors and you have to take in the mitigating factors and then assign weight to them and decide. In that aggravating factors, collective conscience and public opinion is not one of the factors that you can look at. And it is a very blatant error that judges often commit while wanting to give the death sentence. They invoke it in the name of society. They invoke it in the name of collective conscience. Now, as much has been written about this, when you say collective conscience, do you really mean public opinion? How did you arrive at this public opinion? Whose public opinion? I mean, is the judge attributing an opinion to the public, right? How is the judge coming to this determination? First of all, it's an irrelevant consideration. First of all, the judge should not even go down that road, a sentencing judge, right? Second, this is just the judge attributing a certain a need that society feels, and there's no basis for the judge to say that except the judge's own perception, right? But even if even if the judge had a way to do it, it is a completely illegal consideration, and that needs to be kept out of sentencing decisions. But it's amazing how popular it is amongst judges who want to give the death sentence.
In conclusion, Professor Surendranath, you don't sound very hopeful in what this, although you welcomed it, the Supreme Court Constitution bench could achieve. In the Indian Express, you write, the court perhaps quixotically hopeful that the serious problem with the death penalty regime can be fixed. However, the sheer lack of capacity and resources that plague our barely held together criminal justice system betray its ability to be fair. Are you therefore saying that anything less than removing the death penalty from the statute books will not solve this crisis?
I was hoping it would be far less obvious than that, but yes, right? Yes, that is what I'm saying, right? And I think the inevitable path to abolition is through reformation. I don't think there's a way to bypass judicial attempts to reform the death penalty. Judges will always think that these issues of fairness and justice can be reformed. And that is what we are seeing. We are in that phase, right? We are in that phase where the judiciary, the highest court of this country, has recognized that there are serious problems. While people like me might believe that those problems are so entrenched in our criminal justice system that they cannot be fixed. And therefore, we cannot achieve the kind of fairness we need to take away somebody's life. But the courts will and judges will always try to reform it first. And I think we just have to be patient that that incremental realization will come, that our system, there's such a crisis of resources, expertise, will, that we cannot deliver the kind of fairness that is required. This is not even getting into the realm of is the death penalty morally justified, not or philosophically justified. We are not even getting into that. I'm just sticking to a far narrower question. Is the Indian criminal justice system capable of administering the death penalty in a fair manner? I don't think it is. The courts seem to be saying, yes, there are problems. Let's see if we can try and fix it. And yes, so as I said, path to abolition seems to be first through failed attempts at reformation. And that's where we are now.
I said it's a final question, but very quickly, people want to know in our neighborhood which are the countries that have sort of either abolished the death penalty or put it in abeyance, as in death sentences are not handed out. And I did not know this. I was surprised to figure that Sri Lanka, which has this sort of muscular nationalism narrative for God knows how many years because of the war that went on for so long, has put death penalty on abeyance.
Yes, it's been on moratorium, and it's Pakistan had a moratorium until the Peshawar school attack, and has been quite active on the death penalty front. Bangladesh is also quite active. So in South Asia, you have Pakistan, India, and Bangladesh quite active on the death penalty. Nepal doesn't have it. Bhutan doesn't have it. Sri Lanka doesn't have it. But globally, we are in a shrinking minority, right? We have about 145 countries that do not use the death penalty, either formally having abolished it or de facto not using it. We are in a very small minority of countries, and I don't think we will like the company that we keep in that list of countries that have the death penalty.
All right. Professor Anup Surendranath, thank you so much for your time and for the work you do.
Thank you so much, Smita. Thanks for having me.